York home health agencies. My name is Rachel Yanchis, and I'm a Senior Marketing Specialist at Viventium. We're excited to have our Consulting Director of Compliance Services, Yonina Shineweather, CPA, and Hodgson Russ Partner and Labor Attorney, Amina Cannon, this afternoon to dialogue about current updates in New York home health care. If you have questions throughout the presentation, you can type them in, and Amina or Yonina will answer them at the end if there's time. Before I hand this over to Amina, I want you to know that we value your feedback from this session, and we look forward to sharing with you more insights that will help you successfully grow your agency. We'll be recording this session, and a link will be posted to the webinars page of our website at www.viventium.com/webinars. And for more information on our unique offering for home health, check out www.viventium.com/homehealth. Amina, we're looking forward to this session, and I'll hand over to you to get started.
Thanks, Rachel. Hello, everyone. Good afternoon. Thank you for joining us. So we have an aggressive agenda today for the 1 hour that we have with you. So we're going to try to get through everything. But as Rachel said, please submit your questions, and we will do the best to cover them all during the 1 hour that we have. So today we're going to be talking about 24-hour shift post-Andreeva and what that decision means for you and some of the compliance issues that you should be looking out for. We will also talk about disability benefits and paid family and sick leave benefits that all employees almost have to be entitled to, and some of the nuances associated with dealing with those laws. We're also going to talk about the New York City Earned Safe and Sick Leave Law and what that means for home health care providers who are uniquely affected by that city law if they have employees working in New York City. And then fourth, we're going to talk about wage parity. There's never a shortage of questions, issues, or concerns regarding wage parity, and every month it seems there's a new program that professes to solve problems about wage parity. So we'll talk a little bit about where things are with wage parity nowadays. We're going to talk about spread of hours as well. That's our fifth topic today. We're going to cover some of the nuances associated with calculating spread of hours, and from my standpoint, I will talk about the enforcement activity when it comes to spread of hours. We'll talk about overtime and how Viventium offers unique solutions to calculate and pay overtime, and then last but not least, we will cover some new 2020 federal withholding issues. So with that, let's move on to the next slide and talk a little bit about 24-hour shifts. Now, in March of this year, you will all remember that the New York Court of Appeals, which is the highest court in the state, came out with a decision basically resolving years and years of uncertainty regarding 24-hour cases. Now, these are the cases where there is one caretaker at a shift for at least 24 hours, and sometimes there are consecutive 24-hour shifts like that. The longstanding rule in New York, based on an opinion letter from the New York Department of Labor, was that aides could be paid for 13 hours of work, assuming they got 8 hours of sleep and 3 hours for rest. Now, there was a big dispute regarding that seemingly clear standard because workers claimed that they were entitled to pay for all 24 hours simply because they were required to be on the premises and available for work at any time with the patient. So that was the argument that the workers were advancing with much success up until the March decision this year. And just to recap, their position was that all 24 hours had to be paid automatically, no matter how much the aide slept, no matter how much the aide took in breaks, simply because the aide was being required to be in the home of the patient. Now, luckily for us and the survival of the industry, the Court of Appeals disagreed with that position, right? So number one, they rejected that black and white standard that the aide is automatically entitled to 24 hours of pay. However, in ruling this way, the court did create several new obstacles for providers when they deal with 24-hour shifts. And unfortunately, these standards that the court articulated in March of this year apply to future 24-hour cases, but they also apply to retroactive cases. So for those of you on the line who have had 24-hour cases over the last 6 years, all of this that we will be talking about applies to you with respect to those past and old cases. And that's why a number of you asked me, well, with the Court of Appeals decision coming out so well for the industry, why do we still have these lawsuits alleging 24 hours of pay? And as you will see, the reason we still have those lawsuits is because the court standard for what time has to be paid on these shifts has not actually been improved for home health care agencies. So, one of the things that the court emphasized in its decision is that if the aide does not receive even 1 minute of the 5 hours of consecutive sleep, then the entire 8 hours that was designated for sleep time must be paid. All right? So think about that for a minute. How are you going to ensure that you receive certification from the aides that all 8 hours of sleep, 5 of which were consecutive and uninterrupted, were met? You have to make sure that whatever timekeeping and record-keeping system you have provides certification of some sort that the aide received at least 5 full hours of consecutive sleep without any interruption, all right, within an 8-hour period. So that has to do with sleep. The other thing that the court emphasized is that the sleep has to be pre-scheduled. So it's not enough to have the patient and the home health aide decide between themselves when the aide will go to sleep. The aide actually has to have a designated sleep time every shift. And so you may want to incorporate this into a plan of care or on the timesheet, and we'll talk a little bit about that on the next slide. But just keep in mind, it's not enough anymore for the aide to just check off and certify that they received 8 hours of sleep and 3 hours of break, or that there were no interruptions to their non-work time on a 24-hour shift. There will be a lot more proof required of providers before they can exclude the 11 hours for sleep and break time on these 24-hour shifts. Okay, it's not going to be the default rule that you pay 13 unless someone tells you otherwise. That's no longer the default rule. The rule is that each week the aide has to establish that they worked 13 hours, and it's really the employer's burden to have that proof. The other thing that you have to keep in mind when it comes to these sleeping shifts is that there has to be adequate sleeping facilities made available to the home health aides. And I litigate a lot of these lawsuits right now, and I have before this decision came out, where the allegations were that the sleeping conditions for the home health aide were simply inadequate. And it's been the rule under federal and state law all along that there have to be adequate sleeping facilities provided to the patient. Now, depending on the type of a case, it doesn't have to be a separate room, but the aide does have to have his or her own bed to sleep in, all right? And the aide does not have to have their own bathroom, but has to have access to a bathroom when they're on these types of shifts. And then also, that covers the 8 hours of sleep time. But remember, employers are allowed to exclude on 24-hour shifts a total of 3 hours for meal periods. Now, the issue with meal periods is that they have to be completely duty-free time, meaning that the worker has to be relieved of duties during the time that they are taking the meal break, whether it's the breakfast, the lunch, or the dinner break. You can break these meals up into half-hour periods, but in total they have to add up to 3 hours. And what does duty-free mean? That is the subject of a lot of dispute and litigation. If you have policies that require your 24-hour aides or all home health aides to eat with the patient when the patient eats, the aide is not technically relieved from duty if they're being required to feed the patient or monitor the patient when they're eating, right? They need to have their own free time to eat without any obligations or duties to the patient. So the aide should be free to eat wherever they want and whenever they want on a shift, in consultation, of course, with when the patient is eating. But the less restrictions you impose on the aide, the better you will have of a chance to prove that the meal period was truly duty-free. So if you have handbook policies, and I've seen a number of those in the past and still do, where the aide is required to always be with the patient and always eat with the patient or only eat when the patient eats, then they're not really getting a duty-free meal period, and you have to make sure that that condition is taken out of your handbook and handled a bit differently in practice. So let's go to the next slide, and let's talk about some best practices to ensure that you're complying at least with these standards that we now know are what the courts expect from us, that the DOL will expect from us, and that the Attorney General will expect from us. I just recently settled in the last week a case with the Attorney General, and one of the allegations had to do with 24 hours and the conditions for receiving payment on 24-hour shifts. So I can assure you that the government is adhering to these Court of Appeals standards when it comes to evaluating the pay that's due for work performed on 24-hour shifts. So one of the things I have here on the slide is that your timekeeping systems should document the actual start and end time of the shift, not just the scheduled start and end time. So a lot of systems that home health care agencies use are programs to modify the punch in and punch out time to reflect the scheduled time. You have to disable those types of automatic corrections. You really have to collect the actual start times and end times for the shifts. You also have to start accumulating data concerning the start and end time of meal periods. So whether it's breakfast, lunch, dinner, you have to know when those started and when they ended. You'll have to get confirmation that each meal was taken and it was a duty-free meal, the start and end time of each sleep period, the confirmation that the home had adequate sleeping arrangements on each shift, right? It's not enough to just provide this certification at the outset. When the patient's home is evaluated, the aide indeed has to be the one that certifies they had adequate sleeping arrangements. And then confirmation that the aide took their sleep time at a scheduled time, or if not that scheduled time, then the actual time when their sleep time started and ended. You know, it's required that the aide have a designated sleep time, but obviously situations happen where the aide has to be called to duty. The patient may be experiencing an episode or whatever the case may be. The aide may not be able to get to sleep when they were scheduled to go. So it's important that the timekeeping system record the actual start of the sleep time. And I've been working with clients on getting timesheets in order, paper timesheets to supplement any EVV entries on 24-hour shifts, just because of the demanding and the grueling expectations that have now been placed upon providers by this decision. You really need the aide to sign off every shift that he or she received these, I'll call them privileges, on a 24-hour basis. And then last but not least, the timesheet should specify the duration for the start and end time of each interruption to the employee's sleep time. So you do want to have the ability to argue that the interruption was so nominal that not even, that maybe a minute or two of wakefulness on a 24-hour shift is not enough to make the full 24-hour shift compensable, as the court suggests. So it's a good idea to collect that data as well. All right, let's move on to the next slide. And this is a new topic that I'll be briefly covering. We'll talk about disability benefits and paid family leave insurance. So Viventium is great in that it automatically collects premiums for paid family leave from employees' paychecks and remits those premiums over to the insurance carriers who are charged with providing paid family leave benefits. However, there are some nuances with paid family leave that come up that I just want to make sure agencies are aware of, and specifically the conditions for receiving paid family leave. You know, a lot of workers that come and work for agencies have high turnover rates. They work at multiple agencies, and so it's easy to lose track of them. But it's very important as an agency and as an employer to know and recognize when paid family leave or disability leave may apply to a situation. So if you have a home health aide who is pregnant, for example, and who's experiencing some symptoms of maybe it's high blood pressure, maybe it's nausea, any symptom really related to the pregnancy that's making it difficult for them to come to work, and you're made aware of this, you meaning your coordinator is aware of it or your nursing supervisor is aware of it, that really triggers your obligation to provide the aid with New York short-term disability paperwork, okay? Because any pre-birth medical conditions that the aid is experienced are going to be covered by the short-term disability insurance policy that all employees must be covered under. Now, after the baby is born, the employee has the ability to take paid family leave for bonding with the child, and at the same time, they also have the right to take short-term disability to recover from the birth process, right? And so the employee doesn't get to take both at the same time, but the employee does get to choose which they will take first and which they will take second if they choose to stack them. So the employee could give birth and say that they're going to take 10 weeks of paid family leave, and immediately after that, they will take short-term disability insurance for the remainder of their total of 26 weeks of leave. Now, in order to take short-term disability leave after paid family leave expires, the aide will have to prove that they have a medical condition that necessitates the continuation of short-term disability, but I doubt that it would be hard for the aide to get a note from a physician saying that they have postpartum depression or that they have some other medical condition that prevents them from coming back to work. So just critically, it's important to keep in mind that these laws are triggered under certain circumstances, and in my experience, many home health agencies are not providing the notices or are not aware of their obligation to provide New York paid family leave notices and forms to home health aides. The other condition when the paid family leave paperwork may have to be given to an aide is when the aide has a family member who needs assistance because they are ill. So if your coordinator is hearing from the home health aide that they're not able to come to work due to personal conditions, maybe their mother is sick or has to go to the doctor constantly, and the aide is the primary caretaker, maybe it's a sandwich situation type of a circumstance, then you may need to provide the paid family leave paperwork to the aide so that they can apply for that paid family leave insurance coverage. All right. Moving on. Next, I'm going to talk about the New York City Earned, Safe, and Sick Leave Law. And I wanted to just spend a couple of minutes on this one because we received some new guidance from the New York City Department of Consumer Affairs about the sick leave law and how that is interpreted and applied in the home care setting. So just by way of background, we've had the New York City Safe and Sick Leave Law in various versions for several years now. And for a long time, there were specific provisions in the law that only applied to domestic workers, all right? And there was always a question of, well, who's a domestic worker? Because there is a state law that applies to all New York, quote, domestic workers. And when that state law was passed, it's called the Domestic Worker Bill of Rights, that law extended protections of minimum wage, overtime, workers' comp, certain protections against harassment and discrimination. When that law was passed, the intended beneficiaries were nannies, housekeepers, cleaners, individuals who worked directly for the family and not for a home health care agency. So the state law expressly excluded individuals who worked for home care agencies from the definition of domestic worker. And then the New York City sick leave law was passed after the state law, and that also had its own definition of domestic worker. So there was always a question of, well, when we're dealing with a home health aide that works for Alexa, are they covered by both? And so we have now guidance from the New York City Department of Consumer Affairs that says home health aides who are employed by an agency, so for example, Alexa, those individuals are not considered domestic workers for purposes of the city law. And the city law would give domestic workers paid time off after a full year of employment. And so the city is saying that home health aides who work for Lexus have to receive their paid time off, their sick leave, just like all other employees. So under New York City law, as you most of you know at least, there is 1 hour of sick time that's accrued for every 30 hours of work, and that accrual starts from day one of the employee's employment with the home care agency. So the city came out and said, we know what the state law says. I know the state law requires that paid time off be given after a full year of employment to domestic workers, but in our opinion, home health aides and personal care aides are employees of home care agencies, and therefore they must start accruing their sick leave as soon as they start working. Now, I know most of you provide PTO, including sick time, immediately to employees or shortly to employees after they start working for purposes of wage parity and satisfying other laws. But it's important to appreciate this point about how the New York City Department of Consumer Affairs interprets what your status is. Now, I'm not going to go through the rest of the content on that slide because it's kind of meaty, but I wanted to provide it for you there just so you know that the guidance that came out from the New York City Department of Consumer Affairs had some other requirements for purposes of compliance, and those have to do with distribution of policies, how the policies are written. Those are very nuanced. And for home care, you should be very well aware that the Department of Consumer Affairs is aggressively targeting home care agencies when it comes to sick time compliance. This has been something that they've been working on actively and aggressively for the last several years. I've had a dozen cases with them, and they are vicious, and they are out to collect a lot of money from home care providers who don't comply with the sick leave law requirements. Not to mention that their investigators are typically very demanding and expect a lot of voluminous information. So the best thing you can do is make sure you comply so that if they do come knocking on your door and demanding all sorts of information, you will be well prepared to respond to them. Okay. I wanted to take a couple of minutes now to start talking about wage parity, and then Yonina will kind of take it from there. But wage parity is something that I spent a lot of time working on, and that's because there is a lot of enforcement activity when it comes to wage parity. We have the Attorney General, the Office of Medicaid Inspector General also in New York looking at wage parity, and then we also have a number of private lawsuits where home health aides have brought class action cases alleging that they have not been paid wage parity properly as required by law. And so these cases can be very expensive. The government, when they investigate wage parity, they do so under the False Claims Act, and always there is a threat of potentially criminal prosecution for agencies that don't comply. So it's extremely important that wage parity be taken seriously and that you have proper wage parity systems in place. Yonina will talk, like I said, a little bit more about the breakdown of it, but at a very high level, it's extremely important that you collect data on a per employee basis regarding their benefits. And I represent over 100 home care providers in New York, and I can safely say that almost no one does wage parity the same exact way. There are many, many different variations in how providers structure their programs. Some give more cash, others give more transit, etc. There are different ways to do it, and they're all probably fine. However, it's important that you document for each employee the exact benefit that they receive and how that adds up to $322 on the benefit side or $409 on the benefit side, depending on where the worker is working. It's important that you have this data, like I said, on a per employee basis and a per month basis, and that you be able to produce it when requested. Now, when it comes to wage parity, some benefits that are popular and that work perfectly fine are paid time off, and that includes vacation, sick time, and other types of maybe personal leave. Beyond that, it's a bit trickier to make the argument that the paid time off is a legitimate benefit. So, for example, jury leave, jury duty leave is one that I've seen here and there, and that's a bit of a harder argument to make that it's a benefit because very few employees get summoned for jury duty. So, paid leave benefits. Now, statutory leave benefits like the New York Paid Family Leave Law, that's not wage parity because the employee is paying for it on their own, and also it's a statutory benefit. So the government has said that they're not going to give credit for statutory benefits like workers' comp and unemployment. So it's unlikely that they would give credit if the employer was paying the paid family leave insurance premiums. But I could make an argument the other way as well. If there are providers on the webinar who are paying the employees paid family leave premiums, let me know, and I'm happy to take a look and see whether that could satisfy wage parity. The other benefit that's highly popular and common has to do with commuter benefits, transit cards. Those could be a proper wage parity benefit with tax advantages if they are structured properly. So what I mean by that is that the Internal Revenue Code has certain requirements as to when benefits are taxable and when they are paid without tax, meaning the employer is not required to pay payroll taxes on the amount of the benefit. And if the transit benefit is structured properly, then the employee will receive the benefit and satisfy wage parity, but the employer will not be required to pay any employment side taxes on it, and neither will the employee. The only drawback really with properly structured transit benefits is that because of the federal tax bill that went into effect, I believe last January, the benefits, the transit benefit, the cost of it, the cost that the employer incurs to provide that benefit is no longer deducted from the employer's taxes as a business expense. So, your CFOs should be able to precisely evaluate whether the benefit of providing the transit card and the commuter benefit outweighs the cost to the business of providing that. The other types of benefits that are provided have to do with extra pay. So bonuses, incentive pay, recruitment bonuses, retention bonuses, premiums for difficult shifts, or premiums for mutual cases, weekend premiums. Really, any cash that you pay to the employee is going to be creditable for wage parity purposes, just because of the broad definition of benefit. And then, because we're quickly running out of time, I'll just lump the rest of the benefits into this one category. There are various insurance products, whether it's health insurance, long-term disability, life insurance. Those insurance products are all perfectly acceptable as wage parity benefits, as is a retirement plan. And most employees know that in many cases the employer will match a 401k contribution, but for purposes of wage parity, there's no matching required. Anything that the employer puts into a retirement or qualifying plan is non-taxable, so there's an advantage there, and it is a full benefit for wage parity purposes without any risk from the government deeming that benefit to be improper somehow. So I will turn it over to Yonina now, even though I could talk about this subject for hours on end, but I hope that brief overview of the wage parity benefits was helpful.
Thank you so much, Yonina. Yeah, I could listen to you for hours on end when you talk about it. Just two questions occurred to me, and maybe other people are wondering about that too. You mentioned that New York PSL is kind of questionable because it's a statutory requirement. So would that be acceptable, as a wage parity benefit? I'm just wondering, what about New York City pay, sick pay, that is? In other words, under the New York City sick time law, what would you say about that in terms of satisfying?
That's a great question. That is a great question, and I've often wondered that myself. the guidance that was issued by the Department of Health explaining how they will view various benefits specifically says that they will give credit for time provided pursuant to New York City sick leave law. So it is a creditable benefit, even though, like you said, it's one of the benefits that the employer is required to provide and pay for anyway.
Okay, great. Thanks for clarifying that. And my second question, here on the slide that I'm about to discuss when we talk about rates and who's covered and what's covered in terms of type of service, quick review. One of the developments, of course, in 2017, mid-2017, starting on July 2017, was that CDPAP cases were subject to wage parity, assuming of course, they're funded by Medicaid, as CDPAP is. And those became subject to wage parity as well, as we know. And since I'm going to be mentioning CDPAP, I just wanted to know if you wanted to just give us a minute or two update about like what is going on with the CDPAP program, all these developments, how likely that the suit, will succeed against the state, again, and just kind of the status of where CDPAPs are up to.
Sure. So the saga with CDPAP is an ever-evolving daily saga. It certainly caused a lot of problems, what the state has proposed with respect to PMPM, but the attorneys representing CD Paynees were in court on Tuesday afternoon arguing in favor of essentially voiding the PMPM structure, and the judge, just based on everything that could be gleaned between the lines, I think seems sympathetic and inclined to agree with the proponents of CDPAP, but it's hard to say. In these types of cases, the courts have to be very deferential to the government's position. It's one of the reasons that we won on the 24-hour issue. We had the New York Department of Labor supporting our position on that. So the courts are, at a minimum, inclined to grant the government's position. However, in this case, again, from what I can see, the judge is struggling with how the Department of Health came up with that PMPM methodology in view of everything. Typically, in order to put forth that type of a reimbursement structure and to change everything in the manner that the Department of Health did, you would have to go through the rulemaking process. And the rulemaking process requires that a proposed regulation be published, that people have an opportunity to comment and respond, and then the government has to consider those comments and come up with a, quote, final rule. So none of that process has been met here, and I think the judge noticed that and is struggling with that piece of it as well. So I actually feel very good about the CD Paynees' chances of prevailing on this case, but the reason I'm not jumping for joy and, screaming victory yet is because I know that in these types of cases, the government has the upper hand usually, and the judge, if she's going to turn down what the Department of Health did, has to have a really clear, articulable basis for doing so. So I'm not, pulling out the celebratory balloons quite yet, but I think there's a really good chance that the industry will prevail on this.
Great, Amina. Thank you so much. I really appreciate that update and clarification.
Sure.
Now we're actually getting some questions in from some of our participants, and I will try my very best to allow some time at the end. And I see some of the questions are obviously based on your presentation, Amina, and if there's questions that come up as I'm speaking to all our attendees, please feel free to use your toolbar and to type them in, and we'll try to give some time at the end for it. So what we're looking at now are the basics of wage parity, which of course, wage parity payments are based on date of service and location of service and type of service. Date of service every year, starting on December 31st, the rates will change, and you have the little summary chart there on the right-hand side. The location depends on whether it's in New York City, in the 3 counties, or upstate, where there's no wage parity requirements. And of course, the type of service, so only Medicaid, not Medicare, and not private cases are subject to wage parity. And as we mentioned, the CDPAP, consumer-directed programs, are subject as of July 1st, 2017. What Viventium offers is remarkable wage parity support. And as Amina had mentioned, there are almost infinite number of varieties of ways of implementing your benefits. So we're going to take a look just at some of the stuff that Viventium can offer and the flexibility that clients are already enjoying with Viventium. And that is, here's an example where we have home health aide Winnie T. Pooh, who is an aide for the 100 Acres Healthcare Associates. It's an HHA with 50 employees, so that would be, of course, a large New York City employer. And they're using wage parity, Viventium's wage parity pay tool. This is what Viventium would do under the following scenario. Let's say we have March 5th, location of service is Queens, type of service is Medicaid, and the employee, the aide, is paid for this case at a rate of $15. So Viventium will report $1.69 as additional wage, and the $2.40 as supplemental wage, the full amount there. That's your 409. Now, the next case is next day he works in Brooklyn on a Medicare case and also gets paid $15. And there is zero being reported, and the Viventium system identifies this automatically. Since this is a Medicare case and not a Medicaid case, it's not covered by wage parity. Next day goes out to the island. Now he's in Lawrence, working a Medicaid case, getting paid $12. So there's zero additional wage because there is no additional wage provision outside of New York City. And the supplemental is the amount for the counties. That's $3.22. Next day comes back to Manhattan on a Medicaid case, and this time it's a higher paying case. They're paid at a rate of $16. So at this point, the additional wage liability would get reduced from $1.69 just down to 69 cents, and the $2.40 stays the same. Now, what are all those asterisks there? The client can decide the sequence. So if you tell us when you're implementing with Viventium, you know what, if somebody gets paid over the base, the cash rate base, I want it to come first out of the supplemental liability. So then we would show $1.40 as supplemental, and we would still show the $1.69 as additional. That's what I mean when I talk about remarkable flexibility. You can determine what gets reduced first, and then the last day, they're working in Yonkers on a Medicaid case at $15, and so since they are $3 over the base cash rate in Yonkers, they of course have no additional liability, and they have only 22 cents left that they have to get as a supplemental benefit. Now, let's translate this into practical terms. When you talk about benefits, you don't say, okay, here's your additional and here's your supplemental. You say usually, here's your transit, here's your health, here's your vision, here's your dental, here's your PTO, whatever benefits you may be offering. So what Viventium does is that we empower you to give each employee on the employee level, if you so choose, the freedom to choose their mix of benefits. And it can vary, from department to department, from employee to employee. And you, of course, can choose which benefits to reduce first if they're going to get a higher cash wage. So let's look at an example again. Let's assume you're giving $1 to transit per hour, $2.50 to health, and 59 cents to PTO. Let's assume we're sticking to the city now, and we're sticking to Medicaid cases. No trick questions here. Okay, so we're in the Bronx on a Medicaid case at $15. The transit's going to be $1, according to your plan. The health is going to be $2.50. PTO is going to be 59 cents. That's the classic case. Next day they work and they get a $16 base cash rate. So now again, you could decide which one of these you want to reduce first. You just tell us. So let's assume you're reducing it in the same order. So you're going, transit goes down to 0, but health and PTO stays the same. The next day when they're getting 17 an hour, your transit is 0. Your health now gets reduced by the hour. PTO stays the same. If they were to go to Staten Island next day on $18, so the health is down 50 cents. And of course, if they go up to $19, the health is gone and the PTO gets reduced by the extra 50 cents and you're down to $9. So this is all happening automatically with no Excel work or anything that you have to do. You just set it up one time, and this is how Viventium handles it for you. Okay. I want to move on. Again, if you have any questions, please do feel free to type them into the toolbar. I'll try to leave some question and answer time at the end. Let's now talk about spread of hours. Spread of hours is a New York requirement. And, when I mention it to sometimes the clients, when this comes up, they're like, well, what's spread? Where's spread? Where is this coming from? So I just put here for you on the slide, and these slides will be made available to our participants after the webinar. This is the statutory source for it. It's basically written into New York law that an employee shall receive an extra hour pay at the basic minimum wage in addition to all the rest of their hours at minimum wage on a day where there is a spread of hours that exceeds 10 hours. That's where it all starts. Now, we can see it also if you take a look on the wall where you're hanging your labor poster, the poster that you have to update each year, and don't forget to update it on December 31st when the minimum wage, changes. The spread of hours is down here on the right-hand corner. I've highlighted it in yellow for you. It's up there for everyone to see. If your workday lasts longer than 10 hours, you may be entitled to an extra daily pay. Now, that's actually a little misleading. That makes it sound like if you work more than 10 hours, which is not what the law says. The law says if your spread between your first hour worked and your last hour worked is more than 10, you may be entitled to extra pay. Let's give a simple example, and then we'll give a more real-life example. So, simple example. Alex Graham works 2 daily shifts at an hourly rate of $11.20 for Bill's agency, a large HHA in upstate New York. I'm purposely placing them in upstate so that we're not going to get wage parity mixed in. We're just going to talk about upstate. Now, the minimum wage upstate right now is $11.10. This person, Alex, is getting a little more than minimum wage, and he's working from 8 a.m. to 12 noon, caring for Sam Morse, 1 patient in Ellenville, and then from 6 p.m. to 10 p.m., another 4 hours for Tom Edison in Goshen, New York. Bells is asking Viventium to set up spread of hours calculations. What is Alex's daily gross pay? So, simplified example, he worked 8 hours at $11.20. His pay is $89.60. But now we have to compare that to the spread calculation, which means assume he worked all 8 hours at minimum wage, and since he began at 8 a.m. in the morning and he didn't finish his day till 10 p.m., there's a spread there of more than 10 hours, he needs to get 1 spread hour at minimum wage. Even though he didn't work 10 hours, he only worked 8 hours, but because the interval from the beginning of his day to the end of his day was more than 10, he needs to get that extra hour of pay, and so his pay needs to be $99.90. What Viventium will show automatically is the regular $89.60, the differential between that and what he needs to get, which is $10.30, and that'll be labeled spread of hours on his pay stub. And the total gross will be the amount required under New York DOL regulation and law, $99.90. That's a simple example. Now, New York State does give you a little break, and they say, if the total hours for the whole week, everything you get paid for the whole week, if that covers the spread due for the whole week, then you don't have to worry. Then you don't have to pay anything extra. As long as, in other words, if you're paying him extra stuff, bonus, if you're paying him a high enough rate for the whole week that makes up for it, then fine. As long as you make sure that he's getting all his hours plus 1 hour per day that he has spread at minimum wage, you're good. So now let's do an example over an entire week. We're looking at Bob now, who works 2 daily shifts at an hourly rate of $11.20 for Sun Agency, large HHA, upstate New York, fine. From 8 to 12, he cares for Esther, and from 6 to 10 for Harvey. This week, he worked 5 days. So we take his 8 hours a day, times his rate, times 5 days, we would think we want to pay him $448. But now we have to do the spread comparison. And when I say we, I mean this is something the Viventium engine does automatically. It does 8 hours times minimum wage times 5, that's $444. And then since each day the spread was 10 hours or more, so it's a 1 hour spread at minimum wage times 5 days, that's an extra 55.5. And this needs to be Bob's total pay, so Viventium will show the $448 is regular, the differential is spread of hours for a total gross of $499.5. This is something that auditors, when a DOL auditor comes in to a workplace, they love to check, because most people, or a great majority of employers, are not aware of this, and they'll say, oh, but I didn't know, and then usually the auditor will turn around and say the famous line that ignorance is, unfortunately, no excuse. Now, when we talk about HHA, now spread of hours applies to almost every business in New York State. Why do I like to highlight it when I speak to home health agencies? 2 reasons. Since you're dealing often with shift work, where employees may go to work and then have time off and then go back, it can be common that spread will strike often. And when we have retro hours, you know, in our industry, employees love to get in those, you know, oh, I forgot my timesheet, I have an old date of service to report, all those retroactive hours, spread will often strike silently without us realizing. So let's take an example of spread striking silently. Amelia Bedelia is a home health aide for Peggy Parish Partners, a home health agency in upstate New York. Amelia cares for Mrs. Rogers 5 days a week from 9 to 3. Okay, that's not yet a spread. And she's paid $11.10 an hour, minimum wage. For the week ended May 10th, Amelia was paid $333 because that was 30 hours, right? She's working for 6 hours a day times 5 days, 30 hours at $11.10 per hour. That's $33.30, you know, 333. And now, sometime in September, all of a sudden, Amelia remembers, oh, Mrs. Rogers has called me back on May 8th from 8 to 11 p.m. since their family had all gone out to a wedding and she needed me. So Amelia submits those hours now, and Peggy says, okay, fine, another how many hours? Another 3 hours at 11.10. That's another $33.30 on this week's check. Is Peggy in compliance with New York State DOL law? The answer is no, not necessarily, because Peggy forgot to check if spread of hours is due. And if we look back and we see, well, she had begun her day at 9 and she didn't finish it till 11 p.m. at that point, it could well be spread of hours is due. But Viventium won't forget because we automate your compliance. And our software is so flexible that we have spread of hour support for HHA retro hours. And it's all software driven. Once you're set up for spread of hours, this will automatically be calculated. And not only that, but you can also select the minimum wage to use based on location, which is pretty remarkable. So as you know, there's all kinds of minimum wage complexity in New York. It depends on where the work is being done. And in New York City, it depends how big the employer is. But Viventium supports this. The user selects the minimum wage to use for spread of hours. Okay. Let's move on to talk about overtime, and I like to call it the 3 flavors of overtime: vanilla, chocolate, and strawberry. Retro overtime, automatic overtime, and the big one, multi-rate overtime, which is sometimes called overtime premium. So used to be, before 2015, home health aides were not necessarily subject to overtime requirements under federal law, but that has changed. And since 2015, I don't know if many of you remember that cliffhanger we had, the back and forth, but it's clear now that home health care aides are subject to the Federal Labor Standards Act. And when it comes to retro overtime, you know, like we just said, those employees love to give in hours late, you know, after the pay period, sometimes after the quarter. What does that do to your overtime calculation? Well, with Viventium, it doesn't cause any problem at all. So let's take an example of John Bach, who was an aide with Music to My Ears agency. He had submitted a timesheet back in February showing only 35 hours worked, no overtime that week. And yet on his June timesheet, he reported 46 hours for the week of June, the week he was in, and then he remembered he had additional home visit of 7 hours that he had never reported for February, and he had forgotten to report it earlier. What overtime will Viventium show on John's paycheck, and at what rate? So here we go. First of all, then he had reported 35 hours back in February. Now he's remembering another 7 hours. That means another 5 regular hours, right? And 2 overtime hours. These 2 overtime hours will be paid. Viventium will automatically pay it at 1.5 times John's regular rate for the February weekend. Now, this week, he's reporting 46 hours. That means 6 hours of overtime. And that's going to be paid automatically without you doing anything at 1.5 times the regular rate for this week. So the total overtime on this check is going to be 8 hours, but paid at 2 different rates. Same thing about automatic overtime. A lot of popular time and attendance packages like to give a dump, just total hours or daily hours. and Viventium will allocate those hours appropriately between the regular and the OT pay based on your state wage and hour law and any particular rules that you may have. So for example, if you have an aide where your TNA software is exporting 45 hours for him, Viventium, you don't have to do anything. Viventium will automatically separate 40 to regular and 5 to overtime. Now, let's say you have a policy of paying up to 45 hours, regular time and a half, overtime at time and a half, and above 45 hours double time. And we get an export from your TNA of 47 hours, and you set your rule up with us. We will automatically pay 40 hours at regular, 5 hours at overtime, and 2 hours at double time. Now we get into the big one, the strawberry, and that is overtime premium. So according to FLSA, we know that any hours over 40 have to be paid at time and a half the regular rate. And there's a lot of misconceptions and a lot of mistakes, and unfortunately, under labor audit, a lot of back pay being due if overtime is not done properly. So the most common mistake is let's do overtime at time and a half of the rate on the day that overtime was worked. Well, if you're earning the same rate all along, that's no problem, that's great. But if you're earning different rates, that obviously doesn't work. And the second mistake, which is a little more subtle, and we're going to see it in a minute with the numbers, is that employers will pay overtime at the weighted average rate only, which sounds good, but we'll show why in a minute it's not correct. And the third, which is unique to New York because of the Wage Theft Prevention Act, is not disclosing the regular rate for the overtime hours on the pay stub. Okay, let's take a look what this means. Here is a picture of Joe March, who worked at the rate of 15 and a half, an increasing rate, 10 hours a day, so that by the time she got up to Friday, she was over 40 hours. She has 10 hours there of overtime, and the total hours worked was 50, and we add up her pay, $800. What's wrong with this picture? Well, obviously, overtime is missing, so we'll say, fine, let's look back. So she worked 17 hours, so overtime is time and a half of 17 hours. That's common mistake number one. That's obviously not the way to do it. It could sometimes come out costing you a lot more than you have to be paying, and sometimes you could be willfully underpaying. The question, as we know, has to be, what is the regular rate? So the regular rate is the total pay, $800, divided by the total hours, $16 is the regular rate. Okay, that times 1.5, $24, that would be the overtime rate. Okay, so if the weighted average rate is $16, we multiply that by 1.5 to get $24. And we say, okay, so we're going to pay those last $10 at $24. Is that going to work? Well, I try it here. I plug in the $24, and then I take another week where she worked the opposite. She went from 17 to 16 and a half to 16. The rates were in the opposite order. And the last day, I plug in 24 hours. And no, it's not working because she worked the same number of hours, the same basic rate. The order of the days that she makes them shouldn't make a difference. And yet I'm coming out with 2 different paychecks. So obviously, this can't be the way to do it either. This is the second common mistake. The right way to do it is to say, okay, I'm putting down the regular rate, 17 or the 15, whichever week it was. I'm saying, okay, my regular rate is $16. My overtime premium rate is half of that, $8. And since she worked 10 hours overtime, that's an $80 OTP. And I'm going to show that on the check stub as OTP of $80. That is the compliant way of paying overtime. And when we do that, then we see the pay comes out the same no matter the order of her rate. Doesn't matter which one she worked first or second. This would be good for many states, but in New York, even this is not enough. Because New York requires, under the New York Wage Theft Prevention Act, disclosing the regular rates and the overtime rates. So if I just say, okay, here's the regular rate, here's the overtime premium, here's the total, I'm not disclosing the overtime rate. And so I have to add this little line, which Viventium will add to your check stub for wage disclosure purposes. OT rate based on the weighted average is $24. When you change to a compliance check stub, Viventium will never do this for you unless you sign up for OTP. You say, okay, I want to enroll in OTP service. We do not provide legal advice. Any legal questions should go to Amina, a wonderfully capable labor attorney. Always consult with your attorney or your CPA, of course. This idea of overtime premium works with retro hours as well. So like if you go back and add hours for an earlier week, we will redo the OTP as needed. And I just put in a little note here that if you do have mandated paid leave, what rate are you supposed to pay that paid leave at? You would be using the regular rate, the blended rate, the weighted average rate for that. Now, a lot of times if you're going to change your stub, employees are going to have lots of questions like, what is this OTP thing? How did you get to it? Why does my stub look different? If it says my overtime rate is $24 and I work 10 hours overtime, why am I not getting $240 of OTP? You may have lots of questions. So the Viventium is always in it with you to try to help you help your employees. We've prepared a PDF document that is written in layman's easy to understand language, understanding your overtime pay, and it's in question answer format. Any of our existing clients can request it, and we're happy to provide it. That just helps employees understand how their overtime is calculated and how they can figure out their rate. And as we're drawing close to the end of our webinar, and I know there are some questions that I want to leave some time for, I just want to do a nod in the direction of the new federal withholding tax going into effect in 2020. And it's important to be aware that federal withholding is changing. As per the TCJA of 2017, it took the IRS a while to actually implement it totally, but now they're geared up and ready to go. The goal of these changes are to decrease employees' withholding and thereby increase their net pay, decrease their refunds. So instead of withholding a lot and then giving them back money at the end of the year, the idea to stimulate the economy is let's put that money, let's not over withhold, let's put that money into their pay envelopes each week or every 2 weeks and give them the money up front. Now, the unanticipated, unwelcome consequences of this change is that unfortunately there is increased complexity, decreased privacy on the W-4 form that employees are being asked to fill out, additional employer burden as you'll be, facing questions that your employees may ask, because the new W-4 really looks like a mini 1040. So even though the withholding methods have stayed the same for 2019, the IRS is encouraging you to encourage your employees to do a paycheck checkup using the IRS calculator, and I gave you the link for it on one of these slides. What is changing for 2020 is there's going to be all different kinds of ways of calculating taxes. First of all, there's going to be 3 marital statuses now, not 2, married, single, and head of household. Second of all, there are going to be 2 kinds of tables. Use these if the form is from before 2020 or it's only 1 income, and use the new one if it's after 2020 and there's 2 incomes in the family. So there's going to be 2 different sets of tables. Now, for all the Viventium clients, this is going to be transparent because we're supporting this for you. But I just want to give you a sneak preview at the most recent draft that the IRS has put out. And they basically said, this is it. This is what it's going to look like. They're just going to adjust a few numbers. But this is the new W-4 that new hires are going to have to fill out, not existing employees. You don't have to get all your employees to fill out a new 2020, but new hires will need to use it. And of course, any existing employee that wants to make a change is going to have to convert over to the 2020 form. As you see, you have 3 statuses now, including head of household. You have step 2, where the employee needs to indicate if they have a multiple job in their family. Now, they don't have to fill this out if they don't want to. They could go use the IRS calculator tool. But if they want to get as accurate as possible without doing that and without doing any worksheets, they can just check a box where they indicate that they do have 2 incomes in their household. They are given a place to claim their child tax credit, $2,000 per child under age 17, and to optionally report any other income like interest, dividends, bank accounts, and any other deductions or adjustments they may have. Note that there is no longer a checkbox for exemption from withholding. If an employee wants to claim exempt, they're going to have to pencil it in. They're going to have to write it in here in hand. So it's going to get a little more complicated. We do have a few different resources available to you. We're going to be conducting some Viventium webinars upcoming. Rachel will mention those about the new withholding for 2020. And you can find additional resources coming up on our website where we're going to have some videos and podcasts that you'll be able to reference about the new withholding. And now, Amina, if I can just run a question by you.
Okay.
That Okay, one of our participants asked something you had mentioned, the changes, including the retroactive changes to 24-hour shift documentation. Is that required for both CDPAP and PCA?
Yes, it's required for any worker that works a 24-hour shift. In the PCA setting, the standards are the same, but the question is simply whether the consumer will be solely responsible for any wage and hour issues, or whether the consumer will be jointly responsible for any wage and hour issues to the personal assistant. And obviously these are Medicaid recipients. They don't have resources. So if their PA is upset about not having been paid, the PA will surely sue the fiscal intermediary for any wage deficit. So it's in the fiscal intermediary's interest to make sure that the documentation is accurate, complete, and correct. So the fiscal intermediary should ensure that they have these 24-hour certifications on file and that the PAs are using them.
Thank you so much, Amina, for clarifying that. And we are out of time, so I'm just going to ask Rachel to provide some additional resources. And thank you, everyone.
All right.
Thank you, everyone.
Thank you so much, Amina and Yonina, for an awesome webinar. As always, if you're interested in learning more about Viventium and our payroll and HR offering, you can visit us at viventium.com/homehealth. And then please join us on Wednesday, October 23rd from 2 to 3 p.m. We're going to have an in-depth discussion on how to prepare for the federal tax withholding changes coming in 2020, as Yonina mentioned. At any time, you can register for our webinars at viventium.com/webinars. And if you're interested in hearing more from Amina and Hodgson Russ, you can email Amina at eporican@hodgsonruss.com. And please also follow her on LinkedIn for New York home health updates. Thank you and have a great rest of your day.